So, welcome to my series where I go over the bankruptcy petition. Now, here as you can see on the screen, I'm focusing on official form 101A, what's dealing with evictions and the filing for bankruptcy. Now, I already posted the video on the first part of the forms you have to fill out, which is official form B101, which is the voluntary petition for individuals filing for bankruptcy. So, this may or may not apply regarding evictions, but there's two forms here that I want to go over briefly and just give you an idea what's the important part when it comes to focusing on evictions, whether you're a landlord or whether you're a tenant. Now, the form kind of speaks for itself, right? This is just telling you if there's already a judgment against you by the landlord. And as you can see here, this is official form 101A. Now, we have a form official 101B, which is a statement of payment of eviction against you. This is what I want you to understand most importantly about evictions. Before the Bankruptcy Abuse Prevention Consumer Protection Act of 2005, it was easy for tenants to delay the eviction process. I remember I had one case where even the tenant bounced a check on me, so I wasn't representing her anymore. But she was causing this delay for months for the landlord. I remember that I spoke to the landlord outside of the courtroom, and this poor man was basically in tears. So while I'm very critical of the 2005 law change, especially with the means test and the credit counseling, because it serves no purpose, this is different. The reality is there was an abuse when it came to evictions, and this basically takes care of it. Now, there's a couple of things that you need to know. Um, First of all, the landlord can ignore the automatic stay. And remember, the automatic stay is what prevents lawsuits from moving forward, like a garnishment, foreclosure, or car repossession. They're treating evictions differently. And so the landlord can ignore the automatic stay if the bankruptcy was filed after the eviction judgment was entered. Now, some states, depending where you reside, do have the opportunity to allow you to catch up with your rent. But this is where I say these changes in the 2005 law change is more like an eviction. Because an eviction, and I represented a landlord that had hundreds of properties, you all the evictions, everybody seemed to be doing the same thing. They were just filing a response to the eviction notice to buy more time. And they didn't understand that when you go to court, the judge says, yeah, I'll give you more time. I'll give you to the end of today. If the judge was in a good mood, they give you till Friday. And then I would just have to go back to court on Friday, say nothing's changed. I haven't received any of the funds yet from the tenant. And so I would get an order being able to move forward. This is what's basically happened. You could contest the eviction, right? But the money for the rent has to go into the court registry, in this case with the bankruptcy clerk. So I never, not one time of all the evictions that I have done for this one landlord, not once did I have anybody deposit the money in the court registry. Think about it. Even if we just stop at 100 evictions, not even one out of 100 did that happen. So keep in mind that your state may offer that opportunity to slow down or basically stop the eviction, but you still have to continue paying rent. And so this is why I compare it to eviction process, which is the winner gets all. If the tenant is right at the end of the day, the tenant gets their money back. Maybe there's a legitimate reason to contest the eviction. If not, the money goes to the landlord. So keep that in mind. Now, if there's any confusion, remember, understand that the automatic stay is not permanent. Landlords can move to set aside or lift the automatic stay, and that's done regularly, especially in foreclosures. You realize that the person files a Chapter 7. There's no reason for them to stay in the home with a Chapter 7 if they're in foreclosure. So the lender will file a motion to lift the automatic stay. Sometimes you see it as well with cars if the same thing, if a Chapter 7 was filed. So keep in mind that you have these two forms to complete when it comes if there's an eviction against you. Here's the first form. The forms are explanatory, self-explanatory in that regard. There's really not a lot of information there, but the biggest issue is, if you're going to stay in the property, if your state offers that protection to bring up to date the rent, But again, you're going to have to go through the process. Now, my experience has been, because I've had debtors that come to me and are trying to delay the process, and I explain, well, with the 2005 law change, that doesn't really apply much anymore, maybe 30 days on the max. You're better off just trying to work out a payment arrangement. From a practical standpoint, do you want to stay in a property where the landlord is trying to evict you? Probably not. I understand the difficulties in that, especially if it's money is tied into this, but try to work it out. If not, there's always Chapter 13 to try to, have the arrears and rent included in a payment plan. But Chapter 13 is a lot more expensive when it comes to attorney's fees. And if you try to do it on your own, understand that the success rate is something like 3% of those who are self-represented. Okay, so thank you, and make sure to look out for the other video that I already posted regarding the bankruptcy petition, which is official form B101, and I will continue posting all the different parts of the bankruptcy petition.